Hello to everyone that is watching this program. This is the first activity of CIArb Brazil branch in the year of 2023, and I think it's still time to wish you all a very happy and successful new year. Special greetings and thanks to Lauro Parenti and the Arbitration channel for the partnership in this program, Momento CIArb Brazil, featured on every second Wednesday. This is a program coordinated by Cesar Pereira, fellow and chartered arbitrator, former president of CIArb Brazil branch, actual treasurer. Cesar is a lawyer, partner at Justin Pereira, Oliveira and Talamini, specialized in infrastructure and also acts as an arbitrator. My name is Cristina Mastrobuono. I'm a fellow and vice president of CIArb Brazil branch, independent arbitrator, mostly in disputes related to infrastructure contracts and corporate law. The purpose of our program today is to offer to the audience a glimpse and insights of international arbitration from a continental European perspective. And for that, I welcome our guests today, Dr. Rouven Bodenheimer and João Vitor Costa. Dr. Bodenheimer is a lawyer, mediator, and arbitrator based in Cologne, Germany, one of the very few charter arbitrators in continental Europe, and current vice president of the DIS, the German Arbitration Institute. He's co-founder of Bodenheimer, a law firm specialized on international corporate law to construction disputes, both as party counsel and as arbitrator. João Costa is a Brazilian promising lawyer. He holds a bachelor's degree from Universidade de São Paulo and is a recent graduate of the International Dispute Resolution LLM from Humboldt University of Berlin. He's currently working as associate at Bodenheimer in the International Dispute Resolution practice. I thank you both for being available and sharing your knowledge with us and our audience. And with this brief introduction, I hand it over to you, Cesar.
Thank you, Cristina. It's a pleasure to be back with the CIArb Brazil Moment, and especially having Dr. Rouven Bodenheimer and João Costa here with us. And I'd like to start, Rouven, if I may, asking you a question. You are an experienced arbitrator based in Germany, as Cristina just told us, but handling disputes in a global scale across Europe, Middle East, and Asia, both as counsel and as a neutral. And picking up on something that Cristina just told us, you have just recently been elected vice president of DIS, the German Arbitration Institute. What can you tell us about the biggest challenges you are currently face in all these roles?
Well, first of all, it's wonderful to see you, at least virtually, here again. Let me thank you for the very kind invitation. And at the same time, let me congratulate you on this fascinating format. It's very inspiring, and I can already tell you now it's definitely something we will consider whether and how we can bring this to continental Europe. Allow me also to wish you all a happy new year, those who are watching us now and those I can see here on the screen. To your question, I think the last year for me indeed has been mainly been dominated by the challenges we faced within the DIS. It was a very exciting year. It took a lot of time and resources. We had to replace the Secretary General, which left us pretty much the board of directors and foremost the three presidents with the task of running the organization over almost 1 year. And we are very, very glad that since January this year, we have a new Secretary General, which is Ramona Schad, a female lawyer who has worked several years in a large international law firm, and the last 10 years, more than a decade, actually 12 years, with Siemens, who is known probably to all of you. So we are very confident that this is a wonderful basis with the entire team at the DIS to bring DIS to the next level and face all the challenges in a very good manner. And also, last but not least, to allow the board of directors, which is an honorary office only, to focus again on their main tasks. I think in the private practice, and this is a good linkage, and also the institutions had to deal with the issue of sanctions in a time of global crisis, and to deal with the question to which extent actually such sanctions should apply and should be applied to colleagues in the legal profession. And the institutions in Europe managed to ensure that they are exempted from being sanctioned for advising or being involved in any business that relates to Russian parties and disputes with the involvement of Russian parties. It is, I think, an interesting question, both from a legal point of view as well from a moral point of view, whether or whether not and to which extent such sanctions should be imposed on us as members of the legal profession as well, or whether we shouldn't rather be exempted as well. Another challenge, and again, this bridges to our private practice. I think it's fair to say that when I look back, we are extremely humbled and blessed, both in the institution DIS as well as here in the law firm, of having a team of great individuals, wonderful human beings, greatly skilled lawyers, amongst them João and other foreign lawyers, about which we will maybe talk in a moment. But we are still struggling, and it gets more and more difficult to find suitable new team members. The employment market is a very difficult one, I think, for the entire legal profession. And on top of that, both in the firm as well as with the DIS, we try to foster and promote diversity. And I think this is worth a topic of its own. But the real challenge, I think, among many others, is to realize that diversity is not only gender diversity, as much as this is of relevance, but all other kinds of creating a diverse work environment. And I think that's quite challenging in these days, and we hope to get a little step ahead, at least in the upcoming year 2023.
Thank you, Rouven. I'd like to ask you a quick follow-up question about DIS, specifically related to Latin America. Do you see much involvement of Latin American parties and neutrals at DIS, and do you see room for growth in that regard?
I think that were several questions, so let me start with the last one. Yes, Cesar, we see a lot of potential and a lot of room for growth of a greater involvement of South American, both individuals, parties and stakeholders within the arbitration and dispute resolution market of continental Europe and in Germany in particular. We are looking back, and probably you are the first we are revealing this to a new record year in number of cases which have been administered by the DIS. We have in 2022, I think, almost 170 cases that have been administered by us as new cases coming in 2022. Some of them do involve South American parties. Some of them do involve South American neutrals. And specifically in light of the ever-growing ties between Brazilian institutions in particular and the DIS, I think it's fair to say that not only there's room for growth and involvement, but there is already a great basis to further develop this cooperation and also to enlarge a market for Brazilian and other South American colleagues in continental Europe.
Thank you. That's very good news. And I'd like to turn to João Costa now. And well, João, you know our market in Brazil very well. You have worked here for several years as a lawyer. And having this dual view now, the dual standpoint now, what do you think are the most remarkable differences you have encountered since moving to Europe?
Hello, everybody. Good afternoon from Berlin. First of all, I'd like to echo the words said earlier. It is a pleasure to be here talking to you. I would like to wish everybody a Happy New Year, a very successful one to everybody. And coming to your question, I think there are two big differences that I see now that I work here in Germany with international arbitration. The first one is that arbitration here in Europe is actually more advanced in some subjects than it is in Brazil. So, for example, when it comes to antitrust disputes, the discussion that we have here in Europe is already further. So, for example, it is about the scope of review of an award by the courts, whereas in Brazil, we're still discussing if these disputes are arbitrable or not how they're going to be referred to arbitration. Another topic that is more developed here, for example, is the shareholders disputes. And DIS, for example, they have a set of supplementary rules when it comes to that. And again, this is still in its baby steps in Brazil. And when you face these new subjects, the discussion of these new subjects, you have to keep up the pace and actually walk faster to reach the discussion level that is being discussed right now here. And of course, this takes some efforts. And the second big difference that I see here is actually kind of related to the interview you had with Ricardo Aprigliano. That is arbitration in Brazil. We have a very strong market that is very linked to the court practice. And the international practice is very different when it comes to other topics. So it took and it takes every day a lot of effort to step away from my Brazilian mindset of how an arbitration should be conducted in Germany or anywhere else. And to have in mind that each case is a case with its specificities, and we really have to be flexible and open-minded to deal with all of them in a very efficient way.
Thank you. If I may, Cristina, it's very good to hear what you said about the way some of these topics that are being discussed in Brazil are more advanced in Germany in a way, because they are, as you said, they are being developed in Brazil right now. Both antitrust disputes and shareholders disputes are very important and are the subject of very intense discussions. And so it will be good for us to be able to interact with you and maybe develop those topics here in our market with your help. Thank you. Cristina, sorry.
No, it's okay. Well, there's sure a lot of very hot topics going on in Germany right now that are very close related to what is the future of arbitration in Brazil, mainly this antitrust cases. And well, I would like to turn now to a practical issue also related to the differences of practice in Brazil and Germany. João, this is first for you. And this is related to the production of evidence. So you work in the team of Bodenheimer, and I assume you are involved in many construction cases as well. So what, considering the cases you acted on, is more usual in Europe related to the production of evidence? The model of tribunal-appointed experts or the party-appointed experts? Do you see big differences in comparison to Brazil, where the most usual is the use of the tribunal-appointed experts?
Well, I think I can be pretty straightforward in this answer. Yes, I've been involved in quite some construction cases here, some construction arbitrations. And actually, I've never seen any case where the tribunal appointed its own expert. Actually, all of them, they were conducted, they were the ones that are already terminated, with party-appointed experts only. Back in my experience in Brazil, I've had some cases without tribunal-appointed experts, but in general, all of them, they were with party-appointed experts and tribunal-appointed experts. The big difference that I see here, actually, you can see that this affects costs to the parties when you don't have a tribunal-appointed expert. But most of all, I think that the most important for me is actually efficiency, because you don't have a lengthy evidentiary stage when you simply avoid calling in a tribunal-appointed expert. And in the end, the quality of the award and the quality of the discussion is pretty much the same.
This is very interesting, but I think I have to clarify that actually in Brazil, we don't have the practice of a party-appointed expert in the way that, in the role that a party-appointed expert assumes in European law. So, because I assume that these party-appointed experts, they act also with the obligation of impartiality and independence. Yes, and what we consider in Brazil as party-appointed expert is actually an expert witness that acts in favor of the client. So we don't have the practice here of party-appointed expert in the sense of what it is considered in Europe. And maybe this is a range that can be, this is an area that could be explored in Brazil, but nowadays it is not. So I think this is important to also to clarify, to understand these differences. And now turning to Bodenheimer. So you were in Brazil last year in October, and during this visit in a panel that you took part, you mentioned that you have a preference for party-appointed experts, exactly because of the efficiency in the proceedings, and also to avoid the delegation of the decision-making process from the arbitrators to the experts. So can you tell us more about that? Is it a personal approach as an arbitrator, or is it also common in the proceedings where you serve as counsel? And then also, well, considering what John said, that this is the practice, how do you deal with the experts to achieve the best result? For instance, joint reports, witness conferencing, hot tubbing. So what is your approach? And also another question, how usual is the use of the Sachs Protocol? And I ask that because in every studies that you have in Brazil about the production of evidence in Europe, you find something referred to the Sachs Protocol.
I cannot promise that I keep in mind all the questions, so please feel free to get back to anything I might have missed at the end of my attempt to answer everything profoundly. Let me start by sharing one general thought with you, and this is that I personally think not always, but more often than not, we see any discussion led in our field with quite a clear view on certain issues. And that might be helpful to develop further and to allow for a fruitful discussion. But in the very end, I think we must not forget, and the taking of evidence is a wonderful example, that the key feature we have to offer is flexibility. And whoever says this is how it should be done, or it's the opposite, I'm also sure in the best sense that this is not meant how it's said. Because I think we are far more too often tempted to do the next case in the way the last case or even the last 10 cases went very well. But we must ensure and we must force ourselves to look at each case from a new perspective and look what is the most effective, what is the most helpful way forward for this particular case. And this is the same with the taking of evidence and experts being involved. Now, indeed, my starting point is that I have seen very good experiences with party-appointed experts. And Cristina, you mentioned it rightfully. All of them are independent and impartial, but at the same time, I ask you and also our audience, have you ever seen any party putting forward an expert that in his or her impartiality and independence is actually putting forward a case that is detrimental and harmful to your own views? I have never seen that. So there comes the concept of impartiality comes to a natural limit, I would say. So why is it then, why can it be more effective, or why can it be a way forward? Well, I think for two reasons. The one is the risk I have seen sometimes by appointing only one expert by the tribunal is that you face the danger of replacing the arbitral tribunal's own judgment by the outcome of the expert's view. And that is at least significantly reduced if you have two views who are profoundly presented to the decision taker, which is the arbitral tribunal, who has then to draw their own conclusions on the basis thereof. I think that's one point. The other is you will never avoid both parties by exercising their right to be heard to, of course, do that when it comes to expert questions with the support of respective experts, whether they're officially appointed as experts or whether they are just in the second row feeding legal counsel, or whether they're in whatever capacity in the hearing involved by providing a different view and allowing both parties to challenge the expert that has been appointed. I think we very often, more often than not again, end up even in the idea of having one tribunal-appointed expert with three experts being involved in the room. Now, therefore, I think it's totally fair to allow for party-appointed experts. But again, to give you also an example where I think it depends, or where I think I can prove what I mean when saying every case is different, it depends. When we look in the construction industry and we think about quantum or delay experts, I'm sure that our learned audience and also everyone here in this video gathering can easily name an excellent number of several quantum or delay experts. So it is indeed a level playing field where more than one view, again, more often than not, might be very helpful. But then you have areas, we just got a case in today, it's already late afternoon here in Germany, where the issue at hand is about such a particular question that already from the outset, everyone involved says we can identify the number one expert on this question. There is someone on this planet, no one doubts that he is the godfather of this area of knowledge. So that is a good example where it makes a lot of sense that we only choose this one expert, because everyone will subordinate and everyone will follow his, in this case his, or in many other cases her wisdom and experience. And I think in such a constellation, one indeed can save a lot of time and money when it is agreed that there shall be only one single expert. Now, Cristina, to your question, how do we handle it? Well, I think again, what is always favorable is the idea of allowing the experts to liaise at the earliest time and to identify those issues that are actually in dispute. Because we all know, if you look at an expert report and you only bring them together at the very end, you can find out a lot of things, you know, the experts can actually reach agreement upon. And then I always make this underlying disclaimer to say it depends. I think what is a good way forward is, depending on the preference of the council, to either have the experts then separately on the basis of a joint report, which clearly indicates where the experts have a different view, to have them either cross-examined by legal counsel of all parties involved, or have them questioned by the arbiter tribunal. I think, speaking from the arbitrator's perspective, I think that depends on the party's preference, if they have a joint one. And then at the outset, already agree, if need be, on what we all call a hot tubbing session. So to bring those experts on the basis of what you have learned during the hearing together, and really try to sort out in the best manner possible any discrepancies, misunderstandings, or open issues that are needed to be answered for the arbiter tribunal to render a good award. Last but not least, and please again get back to me and remind me of anything I might have missed. You mentioned the Sachs Protocol, an idea that I think has come up and was presented by Klaus Sachs at ICA, I think a decade ago. I hope Klaus would agree with me when I'm saying he also thinks that this is not the solution that fits all situations, but it's an interesting approach. I have seen it actually only once out of several cases. So I would say it was a very innovative approach. It can add, I think, efficiency to a large extent in many circumstances, but I would be hesitant to say that this is now the solution for all and every situation where we need to take evidence with the assistance of experts.
Well, thank you very much. I think you addressed all the range of questions I presented about the taking of evidence. Cesar, please.
Thank you, Cristina. Just a quick comment about the Sachs Protocol. I actually saw it discussed in a case in Brazil in which the tribunal was about to appoint a tribunal-appointed expert, but the parties were having trouble agreeing on a list of possible experts because of conflicts. The tribunal then suggested the Sachs Protocol, in which two experts would be appointed by the tribunal. The parties were concerned about the costs, and they finally agreed on one expert that was appointed by the tribunal, so that they didn't have to pay for two experts. But that was interesting because in a way, the Sachs Protocol encouraged the parties to be more flexible in their positions. And I'd like to ask you, Rouven, now a question that has nothing to do with we were talking before. And João, you're welcome to comment afterwards as well from your own perspective. Rouven, I saw that your firm's website mentions several cases which involved the application of the CISG, the Vienna Convention for the international sales of goods. In some of those cases, involved states or state entities. The CISG is often described as a reliable common ground between countries of different legal traditions in reflection of international best practices in international sales. At the same time, and that's where my question comes from, parties often exclude the CISG in their contracts. How do you see the usefulness of the CISG in practice? Have you encountered situations in which it has been applied in being helpful in contracts between suppliers and the state, such as the one between supplier and NATO member state in your case, and the one you mentioned in on your website?
Well, first of all, I'm more than happy to hear now that someone has a look at our website. We have lengthy internal discussions about the importance of keeping our website informative and up to date. So, Cesar, you make my day by knowing from now on it really makes sense to update them from time to time, because there are people who have a look at it. Why is CISG not as much used? That's probably your question, if it is such a great tool. I think the reasons are as unspectacular as convincing. And this is one. I think it's a lack of knowledge. If we make a survey amongst 1,000 excellent in-house counsel about their knowledge of the CISG, I think in comparison to many other fields and areas, the knowledge is quite limited. And the second that goes hand in hand is the natural phenomenon that we see in many other situations and constellations as well. And that is to say, we never did it like this, so we continue to not do it like this. And you're referring to something, and I stand here to be corrected, that is indeed the stereotype of this statement, because it has been somehow introduced in the majority of globally used standard terms of templates and so on. They always refer to the exclusion of the CISG. And I think these two aspects, foremost the first, are my answer to why it should be used more. Because it's so easy to familiarize oneself with the peculiarities of the CISG, which makes in many disputes, and we have seen that in the firm, makes you superior about your opponent when it comes to a dispute. I think it has a beautiful features. And when we look in the drafting history and the ideas that are underlying the rules of the CISG, it's a wonderful set of rules for truly international trade, because it incorporates in its fundamentals the situation that goods have to be brought or delivered from one place far, far away to another place far, far away. And this is supported, I think, by two more points. The second is, if we look in our civil codes, in our civil law legislation, it's not limited to civil legal systems, then I think most of the mechanisms are quite similar to what most of our colleagues, both in South America as well as in continental Europe, are already very familiar with. And lastly, we must not forget, and of course, Cesar, I'm not telling you that, but we must not forget that the core areas of a transaction, of a sale of goods, is covered by the CISG. However, we always need additional and supplemental rules of a national law in those areas where the CISG remains silent on purpose. And to last, if I may, I try not to skip anything you have raised. So I think you made a particular reference to contracts involving states or state entities. I think an additional feature that might apply to other constellations in international trade as well, a particular feature here is that the CISG, I think, is a set of rules that allow parties to kind of meet on a more neutral basis rather than if they had to choose one national law with the exclusion of the CISG. And that is, I think, something particularly favorable to be considered when contracting with states or state entities, because both sides will save face and have a solid basis for executing their contractual obligations.
Thank you, Rouven. And it's quite interesting to realize that the Vis Moot problem, the Vis Moot in Vienna, is now turning 30, right? It's the 30th anniversary of the Vis Moot. And the Vis Moot problem this year involves actually the application of the CISG to a contract for the supply of drones to a state entity. And so that issue will probably, has been coming up in the memoranda, and will certainly come up in the oral pleadings. And actually, João, I would like to ask you to comment specifically about that. Rouven mentioned very precisely that lack of knowledge is one of the reasons why the CISG is not applied more. But you come from the generation, the Vis Moot generation, right? You come from the generation that has been exposed to that. And Brazil has been participating in the Vis for the past 15 or 20 years. And so we now have quite a contingent, a large number of lawyers like you that have had that experience in during their university years. So how do you see that? Do you see the Vis Moot experience as something that could change this trend in terms of avoiding the CISG for lack of knowledge?
Well, yes, I would just start my answer actually mentioning that sometimes people in Brazil that I know came to realize that their contract and their dispute would be subject to CISG moments after the dispute arose. So they didn't even think that the contract would be subject to the CISG, because it is something that in practice it is very hard to deal with. Personally, in Brazil, I've never dealt with a CISG case that I can remember about. And I think that the Vis Moot and this internationalization is important because, again, it exposes the Brazilian new markets, the new generation, to the international practice of arbitration, of substantive matters as well. So yes, I think that the Vis Moot, and not only the Vis Moot, but also other competitions, for example, the FDI, is interesting for students to get to know investment arbitration, investment treaty arbitration, something that actually doesn't even exist in Brazil, but having the knowledge about it, I think it's important for the professional growth of this new generation that is coming now.
Thank you, João. Cristina, back to you now. Thanks.
Okay, I want to go a little bit back to the DIS. Rouven, you told us about the development, so the incorporation of disputes with South American companies. So I would like to hear your thoughts about the participation of arbitrators. So how open is the DIS for foreigners, non-Europeans? And also, what can you tell us about the arbitration community in Germany? Is it growing? Are there new faces? How is diversity? And I'm asking this also in a personal interest, but also in the interest of a lot of Brazilian arbitrators that would like to be more active in Europe, especially in Germany.
I can say currently I'm speaking to our idols, our role models when it comes to hospitality, to warm-heartedness, and to the ability of making everyone feel welcome and at home. and I could experience this indeed, as you mentioned previously a few months ago, in your home country. And this is something, if you were invited to name 3 characters of a stereotype German, probably none of the one I just mentioned would have made it to the top 3. But this is exactly what we are working on. We want to develop this further or back to an institution that should be known for its openness, for its welcome culture, and for the good atmosphere everyone experiences, both when attending an event, a conference, or when working together with the great team we have at the DIS and the Secretariat foremost. So we are on this basis. And I hope you will also have had the opportunity of, when our term comes to an end, to say, I was there and I experienced it. And indeed, for a German institution, it's extraordinarily warm-hearted, and hospitality is indeed one of the top aspects and characters, I can say. And I can tell you, we are working on this. Our numbers of cases, as I have said, is increasing. Hence, the number of international matters is increasing, and hence the desire and the need for international arbitrators, neutrals, is increasing as well, because the case load and the number of cases does not fit for German neutrals or arbitrators only. Therefore, I encourage you to get involved. I encourage you to come over. On the basis of the number of cases we already have, with a link to South America, I think this would be a good decision. Is the community growing? Yes, it is the number of cases I referred to, and we are currently an organization with more than 1,500 members. That's, I think, a good number. And over the last years, over the immediate past, it has been kept quite stable. We're working on it to increase its numbers. What we have done, and I hope this then answers your question, is we are currently in the process of appointing new members of our appointing body. And for the first time, we consciously look also for foreigners to be a member of this important body, to ensure indeed that when it comes to the appointment of arbitrators and neutrals, we are not limited to our own market, but also at this level already have someone on board who can add value and names which are probably not the usual suspects within the German market.
Okay, this is very good to know. And João, you are a Brazilian, you're a foreign lawyer in Germany. So can you mirror Bodenheimer's words here?
Yes, I can mirror 100% everything he said. And actually, I just wanted to mention a bit more of the DIS 40. So we have here the DIS Under 40 initiative, the lawyers under 40 years old of age. And last year, we had the conference, the DIS 40 conference in September, one day before the DIS main conference. And I was actually very surprised that from the speakers, I would say that at least half of them were foreigners, either from Asia, for example, or other countries in Europe. Most of them related to Germany somehow, for example, working in firms in Frankfurt, but some of them really not related to Germany, and they were invited to speak in this conference. And also the attendees, they were very, very international as well. And this nationality diversity, it was actually very surprising to me. So yes, I can say that the community is growing for the new generation. There are foreigners, for example, that are leaders in the DIS 40 initiative as regional coordinators. And one last comment, I think that the language is still a factor, it's still an important factor, but I don't think it is an imperative obstacle as it was before. And I think the DIS is doing a pretty good job in making Germany more international market in terms of arbitration.
Thank you, João. Cesar.
Thank you, Cristina. João, I'd like to ask you a question before we close. You are, as you said before, you are involved in the DIS 40 initiative, and as a Brazilian lawyer that has become successful in international practice, as you are. If young Brazilian colleagues come to you and ask you about like best advices you could give them to become successful in international arbitration, what would be like your top 3 advices for somebody in that position?
Well, first of all, thank you. I'm very flattered that you already consider me successful in international arbitration. But leaving this aside, the 3 pieces of advice that I would give to somebody that wants to work abroad is, first of all, networking. I mean, be active in the market, get to know as many people as you can, go to events, try to publish articles, get known, because in the end, it's these people that will help you go abroad and attend an LLM, for example, by giving letters of recommendation or even giving tips. And so networking is very important in this regard. Second one, and this I think is very important, I think one has to understand the needs of the market that you're trying to get inside and what you can actually offer to the market. And these needs, they can be as simple as language, for example. You can offer a native Portuguese speaking skill or Spanish speaking, because this skill, for example, will allow the market to get closer to the Brazilian market or to the Latin American market, for example. Sometimes it can be even knowledge or specific practice in some areas. So, for example, you studied something specific in your master's that will actually be helpful in the market that you want to practice. For example, antitrust disputes may be something interesting for the discussion in Brazil, for example. And sometimes it can be even related to purely commercial matters. So you can go to a firm or to a specific city where they are looking for somebody that will help them get into the Latin American market, for example, either by language, skills, or even knowledge of people and networking there. And the last one, which is also very important, don't underestimate the importance of having a proper mentor. So I had a mentor in Brazil. I have my mentor now here in this interview with us, even though he is still frozen, unfortunately, at least for me. And having a mentor is important because it helps you get in the market, it helps you get to know people as well, and it helps to get to grow professionally in terms of technique and everything else. And everybody that I know that from my age that is getting more successful in the area, everybody has their own mentor, people who are helping them get further in international arbitration practice.
Thank you, João. And this has been wonderful. I thank you, João, and you, Rouven, for sharing all those insights with us. And Cristina, I turn it back to you then. Thank you.
Yes, well, the time is very short to explore all the experience and the insights that Bodenheimer and João Costa could bring for us. But I really thank you both very, very much for being here today, sharing a little bit of your time. We know you're very occupied, very busy. And with these words, we finish our session today, and I invite you all to be with us in 2 weeks from now on, where we will continue with our interviews with lawyers that have something to bring for us. So with that, Stay safe and see you in 2 weeks. Bye-bye.
Thank you very much. All the best.
Thank you.
Thank you.
Bye-bye.